This case was decided in 1824 when Chief Justice Marshall wrote that the Commerce Clause confers upon Congress the ability to regulate that commerce which concerns more states than one. The notion that a regulation requiring the purchase of insurance that is central to a comprehensive legislative reform of 1/6 of the national economy is somehow beyond the power of the National Congress is an astonishing proposition. So I'll open by saying, first, this is a regulation of the interstate market in insurance. Secondly, it's necessary and proper to Congress's regulation of the national health care market. Thirdly, it is not so intrusive that one would carve out an exception to what otherwise would be ordinarily assumed congressional authority over the regulation of commerce. It is no more intrusive than, say, Social Security or Medicare. And finally, that the limiting principles seem clear to me and do not mean that if you can regulate this, you can regulate anything. The court will uphold this without seeing anything remotely approaching such a sweeping conferral of authority on the national government. President Reagan's Solicitor General Charles Freed testified on this, and to Charles it's quite simple. The court confirmed in 1944 that Congress has the authority to regulate the insurance market. Southeastern underwriters versus the United States. The court has not for a moment ever backed away from that. Of course, it's a regulation of commerce, and one way to regulate commerce is to create financial incentives for people to purchase health insurance, which this law does. It imposes up to a 2.5% surcharge or penalty on federal income tax for those that don't maintain minimum coverage. That's all it does. That alone should be enough. I actually happen to think it's not necessary to say that requiring the purchase of insurance is a regulation of commerce because it's so clearly necessary and related to what is obviously an indisputable regulation of commerce, and that is the regulation of insurance contracts and the insurance contracting business to say that you may not deny coverage to people because of pre-existing conditions, because of their own health, because the child is born with a birth defect. Congress can undoubtedly do that, and it can, as to make that work, create a financial incentive for people to maintain insurance coverage before they're sick. Now, is there anything so intrusive about that that it should be an example? It is characterized as a regulation of inactivity. What it actually is the use of a congressional power to impose an affirmative obligation. And I will say in a few minutes why we might need a stronger justification for Congress to impose affirmative obligation, but that's what it is. When the Congress in 1792 required every free male adult to purchase a weapon, ammunition, and a knapsack as an exercise of the militia power, no one said, oh, this is a regulation of inactivity. If we could regulate inactivity, we could regulate anything. It's just the imposition of an affirmative obligation, which, again, might require a stronger level of justification, which I will come to. So, is there anything particularly intrusive about this particular regulation? It is, in fact, less intrusive, a less dramatic curtailment of, quote, liberty than Social Security and Medicare. It doesn't apply to anyone. The penalty provision doesn't apply to anyone who is sitting out in the woods and just wishes to be left alone. You have to go into the economy and earn what is $18,000 for a couple in order to have to file a federal income tax for the penalty to be applicable to you at all.